Hi, I'm Matt Culkin, co-chair of Steptoe's Financial Services Group, and welcome to another edition of Financial Services University. Today we're going to talk about economic and trade sanctions, and I'm pleased to have two of my colleagues joining me, Meredith Rathbone in our Washington office, and Nick Turner in Hong Kong. Meredith, Nick, thank you for joining me.
Thanks for having us.
Thanks, Matt.
So today we're going to try and clear up some misconceptions about the sanctions regime, and let's just start with maybe one of the basics. So is it true that sanctions laws are solely focused on US dollar transactions?
People do often focus on US dollar transactions, but the fact is that OFAC sanctions are currency neutral, we'll say. Their jurisdiction really depends on the involvement of US persons, including US companies, US banks, foreign branches of US banks. US dollar transactions can actually sometimes fall outside of US sanctions jurisdiction, believe it or not.
And so what does that mean for non-US dollar transactions?
So that's the thing that surprises a lot of people, especially outside the United States. Because OFAC's enforcement jurisdiction is based on the involvement of U.S. persons, and that includes U.S. banks, you can have situations where non-U.S. dollar transactions actually fall within OFAC's enforcement jurisdiction. So for example, earlier this year, there was a company in the UAE which entered into a pretty major OFAC settlement. And what was really interesting about the case is that some of the transactions which involved North Korea, actually took place in local currency. But what happened in that case is that the company had a bank account at a branch of a U.S. financial institution. And as Meredith mentioned, a branch of a U.S. financial institution is a U.S. person. And so OFAC had jurisdiction in that case. So it's really important for companies, especially when they're operating outside the U.S., to know what the U.S. financial system is, and to be on the lookout for those cases where their transactions fall within OFAC's jurisdiction, regardless of what the currency is.
So Nick, you've mentioned OFAC several times. Before we get too far, can you just explain the U.S. government regulatory infrastructure here?
Sure. So OFAC is the Office of Foreign Assets Control. It's an office within the U.S. Treasury Department, and it is primarily responsible for administering and enforcing U.S. economic sanctions.
And Meredith, is it the case that the government discourages all transactions with a sanctioned territory, or how does that work?
Yeah, they actually don't. They, of course, discourage many transactions with sanctioned territories, and what we call the comprehensive sanctions programs, those that apply to Crimea, Cuba, Iran, North Korea, Syria. Those sanctions regimes prohibit most transactions with those countries, but OFAC has issued guidance recently encouraging people to rely on the so-called general licenses that they have in their regulations for engaging in humanitarian transactions with those countries.
There are actually a lot of general licenses and exemptions in OFAC regulations that permit activities, and some of the most common ones involve humanitarian support, agricultural goods, medicine, but also activities of the United Nations and NGOs. And OFAC really encourages people to take advantage of those, especially around the COVID pandemic and other international crises. The other thing to remember is that U.S. financial institutions are also permitted to process transactions which are incidental to licensed activities. So if an NGO, for example, is engaging in a transaction which is permitted under a license, their bank would also be permitted to process transactions related to that activity.
And I'll just add to that it's important to read the license, whether it's a general license or a specific license that you as a company apply for and receive, or somebody else whose transaction you're facilitating has applied for and received from OFAC. Take a look at those. Many of them, the general licenses, only apply to U.S. persons. Many of these licenses have pretty strict conditions, such as prohibitions on dealings with restricted parties. So if you have a prohibited bank involved in the transaction, that can be problematic. And some of them have reporting requirements. So it's just a good idea to make sure that you know exactly what the parameters of any license are.
And so Nick, how does secondary sanctions come into the picture here?
Secondary sanctions are interesting. What we were talking about earlier when we talked about U.S. persons and the U.S. financial system, those are usually referred to as primary sanctions. It's where OFAC has enforcement jurisdiction to bring some kind of administrative penalty. Secondary sanctions, on the other hand, it's not really a question of enforcement jurisdiction. These are cases where the U.S. government is using its power to discourage non-U.S. persons from certain activities, usually by threatening to cut them off from U.S. markets or the U.S. financial system. This can be pretty scary. And they get a lot of headlines, and there's a lot of strong language that goes with secondary sanctions. It's really important to remember, though, that secondary sanctions are usually limited in scope, so they don't apply to all activities with, say, a sanctioned territory. There's also usually a requirement that the party who's involved in the activity has knowledge of what they're doing, and often that the transaction is significant in some way. Another thing to remember is that if a U.S. person is licensed to perform an activity, usually a non-U.S. person would not be risking secondary sanctions by engaging in similar activity. That being said, as Meredith mentioned, it's really important to know who your counterparty is, to know if you're dealing with any SDNs, and to know what the purpose of your transaction is. If you're exporting goods, it's really important to know who the ultimate end user is and the end use of those goods, because these are all factors that can be considered when secondary sanctions are being considered by the U.S. government.
You know, that raises a question. So Nick, you mentioned SDNs and Meredith, you hear a lot about the SDN list, the entity list, right? Particularly the last few months with different global news events. What are those lists and how are they different?
Yeah, well, the two are easily confused, and one could certainly be forgiven for confusing them, but it's important to know the difference because more and more companies, as you alluded to, Matt, are being added to the entity list, and for different reasons than before. So the SDN list, it's OFAC's list of specially designated nationals and blocked persons. That's published by OFAC. That essentially prohibits U.S. persons from engaging in virtually any transaction at all with the SDN, whether business transactions or otherwise. And it also essentially applies secondary sanctions, applies risks to non-U.S. persons who provide support to those SDNs. The entity list is different. That's published by BIS, which is the Commerce Department's Bureau of Industry and Security, and that's an export controls tool. So I will say I've started to call export controls the new sanctions just because of the proliferation of entity list designations for restricted parties, but they are actually a bit different. One, the SDN list prohibits almost any activity, as I said, by U.S. persons and has these secondary sanctions implications. The entity list applies to items subject to U.S. jurisdiction, items subject to U.S. export controls under the Export Administration Regulations, the EAR. So, they are different from each other.
And how do you go about figuring out whether or not an item's subject to the export control regime?
So there is an analysis that has to be performed to determine if an item is subject to the EAR, or Export Administration Regulations. And this is especially important for transactions outside the United States because the EAR applies to items whether they're inside the United States or outside the United States, and whether a U.S. person is dealing in them or a non-U.S. person. So the jurisdiction is very expansive. The broadest category of items which are subject to the EAR are items which are from the United States or that have transited the U.S. territory. We would just call those U.S. origin items. But there's another category that's a little more complicated, and that includes items which are produced outside of the United States, but they incorporate a certain amount of controlled U.S. origin content. Or in some cases, it's items produced outside of the United States, but using certain U.S. origin equipment or technology or software in their production. And so some examples which have been in the news recently are semiconductors, but this could also be other types of technology, encryption, things which are controlled under the EAR for various reasons, usually having to do with national security, and they require a license, even if those transactions are taking place outside the United States. So for companies that are dealing in items that may be subject to the EAR, really important to do this analysis, determine if they need a license, and if necessary, get some expert help. They are pretty complicated regulations.
They are, for sure, Nick. And one thing that's important to remember is that these restrictions under the entity list are focused on transactions where you have items headed toward the company that's on the list, as opposed to purchasing from the company that's on the list. If you have items that are going to the company on the list, that's when you need to focus on these regulations. There's a recent regulatory change that clarifies or expands the scope of this rule. And if a party on the entity list is a purchaser, a consignee, an intermediate consignee, or an end user of the products that you're exporting, then they would be captured by this rule. That said, I will add a caveat that even if you're only purchasing from a company on the entity list, you're not selling them anything, it's possible that these restrictions nonetheless could apply to you, because if you're purchasing from an entity list company, but you're sending them your plans, your drawings, your diagrams, if you've purchased items from them and you need to do integration of some sort or troubleshooting, then it's possible that you can find yourself in a situation where you're exporting items in the form of technology to an entity on the entity list. So anytime you're dealing with an entity on the entity list and there's some sort of U.S. jurisdiction over the items that you have, including your technology, it's important, as Nick said, to be very careful and very methodical about going through that analysis. And it's also important to conduct careful due diligence and make sure that you understand who is involved in a transaction and what role they play.
And Meredith, just to make sure I understand that, you're saying that this actually applies or could apply to both sides of a transaction. And so both parties need to take a look at this?
That's right. Whether you're, certainly if you're selling to an entity list entity, yes, you need to take a look at this and be very careful. But even if you're purchasing from an entity list entity, because of the possibility that you may be exporting items to them, such as technology, as part of that purchasing process, you need to take a look at the transaction and be careful.
So I want to give you both the chance to share sort of closing thoughts, particularly with the financial services context. But we've covered a lot in a very short period of time. And so I'm curious, right, before we wrap up, if you have sort of that one or two things that you want to leave our audience with today.
Yeah, so I guess I would say sanctions and export controls as well can be quite complicated, and they're not always intuitive. It's important when you're dealing with sanctions and export controls issues to not make assumptions, to actually take a look at the regulations, at the frequently asked questions that the agencies put up on their website. Get help early if you're not certain about something, because these rules and regulations are complicated, and sometimes what they permit and what they prohibit can be surprising to people.
And what I would add to that is that because these areas are developing so rapidly, it's really important to have good sources of information for not only keeping track of the changes, but really understanding what they mean. A lot of the information that is in the media or that circulates on social media isn't always the most accurate. So it's a good idea to find a trusted source, usually an expert, who can help explain in simple terms what these changes might mean for your company. For example, Steptoe has an international compliance blog where we try to keep up to date on sanctions and export control changes. We also have client alerts, and it's really easy to get in touch with our lawyers if you have a question.
And Nick, what's the easiest way to find the blog?
Well, you could go to the Steptoe homepage where you can find a link to it. Google Steptoe International Compliance Blog. It should be the first thing that pops up.
That's perfect. Thanks for plugging that. Meredith, Nick, thank you both for joining me today.
Yeah, thanks, Matt, for having us.
Thank you.
So that does it for another episode of Steptoe Financial Services University, where we dove into the world of economic and trade sanctions. You can watch more of our videos and learn more about our financial services practice at steptoe.com. Thanks for watching. We'll see you next time.